Hi, I'm Bryant. I'm here to talk to you about the healthcare documents used in estate planning. And this should be a 3-minute conversation, and I'm using the Terri Schiavo example in a lot of this, which is a situation that could have been prevented with these documents. And my apologies to anybody related to that family in that unfortunate situation. But estate planning attorneys like to use that as an example. The Designation of Healthcare Surrogate is a document which gives the surrogate, the person you nominate, the ability to make healthcare decisions on your behalf. It's also known as the healthcare proxy in some states, and what it does, it avoids the guardianship situation where a court is involved in this decision of whether or not you are given some sort of medical treatment. And so the document, Designation of Healthcare Surrogate, deals with who's making the decisions regarding medical treatments in nursing homes, facilities, what kind of care you're getting. And the thing you're trying to avoid is the God power, which is giving somebody limited instructions on what you want, and having the ability to choose without instruction. So instruction a lot of times comes from a living will, which is a written document about your intent concerning life-sustaining medical procedures. And it applies when you're generally in irreversible or terminal medical condition, that you can only be kept alive with by artificial means. And that was the big issue around Terri Schiavo, is she didn't have one of these. Her husband said she wanted one thing and her parents said she wanted another. And a living will prevents that argument, because you are saying what you want. The last document that goes in conjunction with the first two is the HIPAA authorization. Congress passed a law that has locked down healthcare information, and the HIPAA authorization gives written authorization for healthcare providers, doctors, hospitals, even health insurance companies to talk about your health and your healthcare history and medical records. So how this all works together is that you nominate a person through your healthcare surrogate to follow out your wishes that you spell out in your living will, and through the HIPAA authorization, they're able to receive medical information about you in order to follow your decisions in the living will. That was a mouthful, but they work together. And it's key that you spend some time thinking about these decisions and coordinating them in your documents. So it goes along with your wills and your trusts. So check out those videos on my website, and I look forward to meeting you.